All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We are here for oral argument in case number CR18 0122, State v. KAVU. Is that right? KAVU. Counsel, each side has 20 minutes for your argument. The appellant can reserve a portion of that time for rebuttal. Just keep track yourself on the podium clock. The proceedings are being audio and video recorded, so when you get to the podium, if you could tell us your name and your client's name, that would be great. We've read the briefs, discussed the case in conference, and with that, you may proceed.
Thank you, Your Honors, and may it please the Court. My name is Michael Alarid, and I represent the appellant in this case, Jeffrey KAVU. As you've read from the briefs, there's 4 issues that have been briefed in this case, but I believe that the most important issue in this case, and one that I'd like to focus through oral argument on to the extent possible, would be the Batson issue. In this case, I think the controlling case here would be the one cited by the state in this case, which would be State v. Paleo. And in State v. Paleo, the issue is essentially whether waiving a peremptory strike during the jury selection process is the equivalent of using a peremptory strike against a minority juror such that it would trigger a Batson analysis. State v. Paleo is a Supreme Court case in 2001, overruled an earlier ruling by a Court of Appeals in State v. Scholl that it said essentially that is the equivalent. It's the same result. If you waive a strike and the result is a minority juror is not seated, that's the equivalent of using the peremptory strike on a minority juror such that Batson would be triggered. State v. Paleo disagreed, said that's not the same thing. They're not the equivalent. Said there must be something more. In State v. Paleo, they basically described the two things as either you have waiver alone or waiver plus. At the outset, I'd like to just state for the record that it is our position that State v. Paleo was decided incorrectly. And I think that is most specifically highlighted in the Ninth Circuit.
And you state that's a state Supreme Court case?
I do.
Aren't we bound by Paleo?
You are. And I just want to state that at the outset because there is a Ninth Circuit case that came out in 2005, U.S. v. Esparza-Gonzalez, in which a district court, a federal district court, had the same issue, whether waiver of a peremptory strike was the equivalent of using a peremptory strike. That district court relied on State v. Paleo and said it's not the equivalent. The Ninth Circuit took that up and said, no, State v. Paleo is wrong. They said...
And we need to rely on the Ninth Circuit disposition as opposed to our state Supreme Court counsel?
Not necessarily saying that. I just wanted to state it at the outset. Even under State v. Paleo, assuming it was decided correctly, and obviously it's controlling here, even under State v. Paleo, the facts of our case here can still establish that a Batson analysis was warranted under the parameters that were highlighted in State v. Paleo under waiver plus. Okay? So waiver plus under State v. Paleo basically said if you waive a peremptory strike and there's some other circumstances, it could trigger a Batson analysis requirement. The 3 options that they discussed in State v. Paleo were, number 1, when discriminatory statements were made by the waiving party. Number 2, when a pattern of strikes removing a specific group is shown and waiver results in the removal of other members of that group. Or 3, where waiver bears on use. Here, there were no other discriminatory statements made that I observed in the record. So I don't think that applies. However, number 2 and number 3 can be applied in this case. The reason is that you could determine from the record in this case that there were a pattern of strikes. There were only 6 strikes total in this case, and the prosecution used one of those preemptory strikes on juror number 18, who was an African-American juror. The defendant is an African-American. That in and of itself triggered a Batson analysis, one that the judge asked the prosecutor to give a race-neutral explanation for using, and the prosecutor complied, gave a race-neutral explanation. The prosecutor in that case also waived his final strike.
But do you disagree with the race-neutral explanation, or with the finding that it was a race-neutral explanation?
I don't disagree that that was a race-neutral explanation that he gave on the record during the case. And I don't disagree that that isolated strike, that the defense attorney didn't overcome that presumption based on that race-neutral explanation if you are looking at the strike of juror 18 by itself. But the reason why the strike of juror 18 becomes relevant is because then the prosecutor waived his final strike, which left the final juror on the panel off, who was an African-American, juror number 50.
But let's say the race-neutral explanation is the prospective juror said that I would never believe anything a police officer says, and I would just disregard. I think police officers lie all the time.
Right, and I think in that situation it would give rise to a strike for cause, and so we wouldn't be under the same analysis of using the peremptory strike on a minority juror.
But in the world of peremptories, if the prosecutor is viewing, if they said, well, maybe I can be fair, I disagree. I've had bad experience with the police in the past, but I can put those behind me. But where it maybe didn't write, maybe the juror was rehabilitated enough to survive a strike for cause, but it seems to be a pretty legitimate reason for exercising a peremptory. We're nevertheless going to factor in the use of the peremptory and the race of the juror that was struck with the peremptory.
Well, I do think it's important to take a look at what the explanation was. And under the record, the prosecutor did try to strike juror number 18 for cause. The juror was rehabilitated, and the judge denied the strike for cause. So then the prosecutor used a peremptory strike on juror number 18.
And were there similarly situated jurors that were left on the jury who made statements similar to juror 18 who the prosecutor did not use a peremptory on?
That were left on the jury? No. I do believe that there were 2 other jurors that made similar statements, but they were far enough down the list that they were not left on the jury.
We were talking about duties, counsel. Is there a duty to explain why you don't use your full menu of preemptory challenges?
In my view, the answer is yes.
And what's your authority? Do you have a case or a rule?
Well, I guess what I would be saying is under State v. Paleo, waiver alone says that no, you are not required to explain it. Okay? But it does acknowledge that waiver plus other circumstances would trigger a Batson analysis, such that as a prosecutor you would have, as a prosecutor you'd have to explain a race-neutral reason for it. In this case, you have the waiver plus. You have the waiver plus the fact that the prosecutor struck an African-American juror in juror 18. So you have a potential pattern.
But it was a race-neutral reason that he gave, and the court accepted that.
Understood. But still...
So how is that a pattern of anything?
Well, it still could be. You don't have a situation where you have no other minorities who were struck during peremptory challenges, and you just have the single waiver. So you do have the potential to find a pattern.
Can I ask, what in your view would be the appropriate next step if the Supreme Court were going to say we don't like Paleo, or we think something more should be done when a party does not use a peremptory? What are you suggesting should have been done? Or
exactly what the court in the Ninth Circuit, U.S. v. Esparza-Gonzalez stated, which is that you treat it just like a strike. A waiver of a strike that results in the unsitting of a minority juror is the same as using the peremptory strike. They achieve the same result. One is an active action, one is an inactive action, but the result is the same.
What kind of questioning is the court going to go through with, in this case, the prosecutor, to determine whether there was a discriminatory intent in not using the strike. Is it okay if the prosecutor just says, I'm fine with the rest of the panel. I think all of the rest of the panel don't give me pause in any way, so I'm not going to use a peremptory. Would that satisfy your concern?
Well, I think instead it just triggers the Batson analysis in the same way using a peremptory strike would. So it triggers the Batson analysis. He gives a race-neutral explanation.
Isn't that what Judge Catani said, a race-neutral reason?
Sure, if that was the reason that was given. But in this particular case, the judge said, I don't believe that waiving a strike is required or it triggers Batson. So prosecutor, explain a race-neutral reason why you struck juror 18. Don't bother with juror 50. So there's no explanation that was given by the prosecutor on this record because the judge didn't ask for it. That was where the error was. And there was no reason not to ask for it. It's not like it would have inconvenienced the court or the prosecutor to say, prosecutor, you're already explaining your race-neutral reason for striking juror number 18. Why don't you explain your race-neutral reason for waiving your final strike, which is effectively struck juror number 50 in the same breath?
Isn't the reason for exercising a peremptory go to the juror that you're trying to keep off the panel? It's hard to – what do you expect – or what might we expect the prosecutor to say about the remaining panel, in this case the juror who is next in line? If he says, I don't have anything against that juror, does that satisfy it? I'm fine with that juror, just like I'm fine with the other jurors that I didn't strike here.
I think that maybe that would be a race-neutral reason. But I think the problem on this record is that explanation was not given because the judge didn't ask for it, didn't even feel that was triggered a Batson analysis. I think what you're saying, essentially what you're saying is, going to the second step of the Batson analysis is, would that racial neutral explanation be sufficient to overcome a Batson challenge?
But I guess
we didn't even get
my
there.
My first question is if the court's required to do something and it just has to do with you're not exercising a peremptory, would it be enough for the prosecutor to say, I'm perfectly happy with the rest of the jurors. I've only used 3 of my peremptories. I don't feel the need to use any more of them. Is that?
Yes, potentially, especially, and that was also something contemplated in Paleo. There was a couple of other cases that were cited where the prosecution did just that, where waived 3 or 4 strikes, and there were minority jurors who were unseated, as well as white jurors who were unseated. So there was a mixed bag. And so in that situation, it could be certainly evidence of a race-neutral reason because everyone else is fine. And, minority jurors might be seated, minority jurors might be left off, but I'm taking what I can get. In this particular case, and the other reason why I think that Batson analysis was required is waiver plus. If you go to number 3, where waiver bears on use. Bears means the weight of, carries the weight of. And in this case, because he only waived 1 final strike, and that final strike resulted in the final juror, who was African American, being left off of the jury, that waiver bared on its use. It was the equivalent of using a strike. There was no...
That language you're quoting comes from the Ninth Circuit case you
No,
wanted to
it
rely
comes
on?
from Paleo.
Okay.
That's
So,
the
counsel,
third factor.
You said that accepting your argument, that you qualify for waiver plus under 2 and 3 on a Paleo.
Yes.
Okay, so how many strikes, accepting your argument, were there removing a specific group?
I'm sorry.
In this case, how many strikes were there removing this is language from the opinion, removing a specific group? 5
strikes were done preemptively by the prosecution. One of those jurors was African American, juror number 18. One strike was the final strike. The 6th strike was waived, and that effectively left the final African American juror off.
Right, right. Well, I think that's different here. So, number 2 says when a pattern, emphasis on the word pattern, of strikes removing a specific group is shown.
Right.
Is one instance a pattern?
Well, I disagree that it's one instance. He used a strike on an African American juror and then waived a strike on an African American juror, so there were 2.
So if you look at the rest of the sentence, it says and waiver results in removal of other members.
Right.
So that seems to be taken care of in the second half of that sentence. But the first half uses the word pattern.
Sure.
Is one instance a pattern?
No, not by itself, but I don't think there was one instance in this case. He struck juror 18, who was African American, then waived the final strike, so it was number 50 was off, so there were two. And I argue that that's a pattern. Even if you find it's not a pattern, it still bears on use under the third factor under Paleo, because it was the equivalent of it, because he didn't waive additional strikes. He didn't say, I'll waive my last three, or even my last two, which is what happened in Paleo. In Paleo, the prosecution waived his last two, which only struck one Hispanic juror, meaning one non-Hispanic juror, presumably they don't describe the race, but one non-Hispanic juror was also struck. So there was that inherent race-neutral reason such that it would not go into factor where waiver bears on use. Here, he only waived one strike, and it was against the final juror who was the African American. So it was the equivalent of it. Whether he said, I strike 50 or I don't strike anyone and 50 falls off, it was the exact same.
Right, and I understand that, but let me read precisely from Paleo. Number 2 says, when a pattern of strikes removing a specific group is shown, and waiver results in removal of other members of that group. So it would seem to me that that's the first half of that sentence is saying, show us a pattern of actual strikes, and then we could talk waiver and what that might mean. So here you would agree with me that there was one instance under that prong, and that one instance is not a pattern.
Yes, he used one preemptively. I would agree with the court on that.
So only 3 would really concern us here.
I think 3 is the stronger of the arguments, yes. I think 3, where waiver bears on use, is certainly the stronger under Paleo, under the parameters it gives. And I do think that under these circumstances, it's distinguishable from Paleo because, like I said earlier, Paleo, the prosecutor waived 2 strikes, and only one Hispanic juror was left off the jury as a result of that. So it was a mixed bag. And the other couple of cases that Paleo cites, one from Ford v. Norris, the 8th Circuit, and one Busquet v. State from Arkansas, same thing. They were waiving multiple strikes, so there was the results were mixed in those cases. So it's race neutral if they're mixed. Here, there was no mixed bag because it was only one strike. So the waiver of that strike does bear on its use. It was the equivalent.
I'm still a little bit puzzled in terms of what, assuming Paleo were to be reversed somehow, or the court were to decide to revisit it, are we to then compare the juror that would have served with, who are we comparing him or her with? Do we expect the prosecutor or the party to go through and say, well, the juror who's next on the list is acceptable, as is this other one, but this one is slightly more acceptable? Is there a need for a comparison if you simply say, I'm okay with everyone else on the panel? Why would we want to go in and say, I like, if someone just says, I like this person better than that one, is that a violation of something if there's no reason to strike them?
Yeah, and again, I would just reiterate what I said earlier, is what I think your question is really getting towards is the second or even the third prong of Batson. And what I'm saying is that under U.S. v. Esparza, the Ninth Circuit case, and basically what it says in there is our holding simply requires the prosecution to provide a race-neutral reason for the waiver of the preemptory strike under the struck jury system when a defendant establishes a prima facie showing of intentional discrimination based on the
and I'm
on
just
the
not sure
challenge
it gets us very
waiver.
far if the race-neutral reason is I was okay with everyone else who remained on the panel. That seems like a race-neutral reason.
Absolutely, and that may have overcome the.
But that's why we would expect this case to be reversed, even assuming this is the argument in the Arizona Supreme Court, by just saying, by failing to ask the prosecutor to state on the record that he was okay with the remaining jurors, that's a reason to reverse the case?
Yes, because I think that would be the result if it was a peremptory strike on a minority juror and no Batson analysis was done. I think we would all agree, well, a Batson analysis needed to be done. In that case, it was objected to. The judge said, no, he doesn't need to. That would be a reversal because no Batson analysis was triggered based on the strike. So what I'm saying is under these circumstances, because it's waiver plus, you just treat it like a affirmative peremptory strike, which is the court needed to do the Batson analysis, didn't do the Batson analysis. So under the record, we don't have information on a race-neutral reason. And so the only remedy at this point is a reversal. And it, like I said earlier, it wouldn't have taken any additional time or effort or anything from the judge to simply say, prosecutor, when you're addressing juror 18, for the record to be safe, address juror 50 as well. And the judge just didn't do it. So we don't have anything on the record to establish the race-neutral reason. You could also assume that the reason that the prosecutor did that was so that he wouldn't have to explain it. He could have said, well, you know, if I strike 50, I'm going to have to explain it. If I just waive it, judge isn't going to ask me. That's not appropriate. It would have created no additional work for the judge to ask him to explain both. So under that third factor, and I'm out of time, so I'll just reiterate it. I think under that third factor, the waiver of the strike in this case was the equivalent of a strike. Batson analysis should have been done. It wasn't, and therefore it has to be remanded for a new trial.
Thank you very much, counsel.
Good morning, Your Honors. My name is Grace Cynthia Claw. I'm here on behalf of the state of Arizona, who is the appellee in this matter. May it please the court, KAVU's claims should be denied and his convictions affirmed for the following 4 reasons. First, the state's waiver of its last peremptory strike does not constitute a Batson challenge. Second, there was no testimonial evidence by Dr. Farring that was admitted at trial, and therefore there was no right to confront Dr. Farring that was violated. Third, it was improbable that the brief pregnancy comment made by Officer Fisher had influenced the jury. And fourth, it was also improbable that stricken testimony about BAC percentages had influenced the jury.
Could I ask you about the stricken testimony on the retrograde analysis?
Yes.
The explanation given by the court didn't seem nearly as strong as the curative instruction, as it were, compared to, say, the instruction given regarding pregnancy. As to pregnancy, the court said there's 0 evidence of pregnancy. You shouldn't consider that in any way. My recollection of the retrograde analysis was more along the lines of, well, there are reasons that we keep evidence out. It kind of comes across as this is kind of hyper-technical, not really saying the evidence isn't pretty compelling, but just there's some technicalities, don't consider that. Why isn't it very prejudicial to have the jurors hear, sorry, that's a wind-up
Okay.
to, let me ask a simpler question. If the court had not decided to strike the testimony, would it have been error to have allowed the expert to testify and give the numbers that the expert did?
Okay. Well, first, just to address your earlier concern,
Rambling.
The curative instruction wasn't as hyper-technical or as confusing as it may have sounded. He did clearly say that those numbers that Stenberg had given, those numbers and those percentages should be disregarded. So that was clearly said. Then after that, there was some language about, earlier I said you disregard anything I say that it's stricken. But he did clearly say at one point, disregard the numbers and the percentages. With regard to your next question, if the trial court had not struck the BAC percentages, you're asking if that would have been error?
Right.
Okay. Well, based on the reasoning the court gave and its reliance on Montgomery versus Miller, it would conceivably have been error, yes. But there was also other testimony that made the BAC percentage evidence cumulative in some respects that was offered by other witnesses earlier in the trial. So in that respect, it wouldn't have been as prejudicial.
Receipts or just other evidence? That
Right,
there was,
other evidence about him consuming alcohol prior to the crash, and that would be the testimonies of his roommate who saw him earlier in the night, the passenger who was in his car who had seen him drink at least, or have at least one drink at the club. There are the bar receipts and the testimony of the bar manager. So together that was substantial enough to, or sufficient enough to infer that he had drank prior to the crash.
Isn't
So
that a little bit different than giving the jurors a roadmap to do their own math and come up with a number of, I've forgotten what it is, 0.223 or something like that, which is very intoxicated?
it's different, but to be clear, if the court had not struck that testimony, then the state is not arguing that it would have been proper. We're just saying that the way that as is, it's not too prejudicial because we have other cumulative evidence that establishes a similar principle.
Why did the court strike that and provide the curative instruction? What was the two-sentence explanation?
Why did it strike the BAC percentages? Right. Essentially, because the state because there was going to be no retrograde analysis presented in the court, at trial, the court believed that the jury didn't have the knowledge and the expertise to apply the numbers specifically without that expert testimony. So,
and there was an in limine hearing? Is that right? A motion in limine hearing on this particular expert?
Yes, there was.
Was that subject raised in the hearing, and did the court assess that in advance and tell the state to stay away from that?
With regard to the retrograde analysis?
To the offensive portion that was cured or right.
Okay. Just generally, pre-trial, a motion in limine was filed to preclude the retrograde analysis as, I guess, in its entirety. The court at that time denied that motion. So the state was permitted to present it at trial. Somewhere along the lines, the state had changed its mind, and it decided not to present retrograde analysis specifically, but they still wanted to have Stenberg testify. And his ultimate testimony included information about alcohol impairment in general, and it did provide some of those BAC percentages. At the conclusion of the direct testimony, there was the motion to strike. Because there was no retrograde to make the BAC percentages relevant or to help the jury understand what the meaning of those numbers were, it was at that time the discussion began as to whether it was too prejudicial to leave the percentages in. So eventually the court concluded then again without that retrograde. Then there was a short voir dire where they again they questioned Stenberg, and through that particular voir dire, the court decided it was too prejudicial to leave the BAC percentages testimony in because the retrograde analysis was unreliable. Did I answer your question?
Yeah, I just wanted to sort of walk that through. There was a motion in limine. The evidence gets passed. We go to trial, and backfilling relief on a motion in limine almost with a curative instruction. And so it just seemed
inconsistent to say it's too prejudicial, so I'm just going to tell the jury to ignore what I've previously allowed them to hear.
Well, I think the distinct, or what caused, or what was the difference here was the pretrial, they thought everything was going to come in, the BAC percentages and the retrograde, but because what ultimately ended up happening was the state decided, I'm not going to do retrograde anymore because it might confuse the jury.
Didn't the jurors hear about the retrograde?
They did not.
They didn't hear anything to be able, I thought there was evidence that they could do the math themselves based on the expert saying that it typically, the percentage changes by X amount every hour. Was that not presented to the jurors?
He did provide general testimony along those lines, but he didn't provide retrograde analysis. Right. He didn't tell the jury this is what
left to do the math by themselves.
That was the claim that KAVU made below, yes. And the court decided not to allow Stenberg to testify about retrograde analysis because it was unreliable, and for that reason, it decided leaving the BAC percentages to on the record would be too confusing for the jury because they wouldn't understand how to apply, or it would be improper for the jury themselves to do their own math. So for that reason, the court struck the BAC percentages.
Can you address the waiver plus paleo third prong argument?
That it bears on use.
Does waiver plus apply here under, quote, where waiver bears on use, end quote?
No, the state believes that here the real question is whether the trial court clearly erred in denying relief for KAVU's Batson challenges. And so we look at the record as it was below, not on what he's claiming now on appeal. Below, KAVU only made an allegation that the state's waiver by itself constituted a prima facie showing. He did not allege waiver plus. And so with regards to your question as to whether it may bear on use, we can't really say it would be speculative, but again, he did not make any allegation of a waiver plus argument, a waiver plus prima facie showing below. And it was for that specific reason that the Arizona Supreme Court in State versus Paleo denied relief to the appellant in that case was because at trial he did not present any evidence to show that by waiving its last two peremptory strikes, which the court noted.
Isn't that because of the court's view that nothing further was required, that nothing is triggered by waiving a peremptory? So he's unable to show more because the prosecutor wasn't asked any follow-up questions.
We don't really know from that particular case exactly what happened below other than what the court comments.
You don't think he at least preserved the argument by saying his waiver resulted in he struck a juror indirectly through waiving a peremptory? Doesn't that preserve the issue for us and the next court to look at waiver plus?
In some respects, yes. But again, the question on appeal is, did the trial court clearly err in denying relief? And in this case, the trial court implicitly found that there was no prima facie showing because KAVU had only alleged that a waiver had constituted a violation. And he didn't present any allegation. He didn't allege below that the waiver bared on its use. He didn't allege that there was a pattern of striking of a cognizable group of jurors. And to note, there is nothing in the record that tells us what the other races of the jurors were. So we don't even know whether juror 47 or 48 was a minority or not. And so that if the state had utilized its strike, it could have struck a minority juror and we'd still be in the same situation. So I think it's just coincidental that the juror who happened to be the next in line was African American. And whether it was, again, just coincidental that it happened to be that case. And to just also note, juror 50, the difference between jurors 47, 48 who were eligible to be stricken at the time the state had its waiver, between those two jurors and juror 50 was the only one who had a brother with a felony conviction. So it is conceivable as to why the state just decided that I'd rather keep one of these two and not risk getting him. So again, I don't think the waiver bears on use argument would hold water even on appeal.
But that you're suggesting, so if the Supreme Court were to say that we do require an analysis when there's a waiver, that would be there would have been a reason that the juror who was indirectly struck, that there was a non-race-based reason for striking that juror?
Sorry, I don't know if I understand your question exactly, but
you're saying that the prosecutor had information about the juror who was indirectly struck that would have provided a race-neutral reason for using
Yeah.
a peremptory on
Yes.
that juror.
If we are going to go back and look at that, yes, it would provide a race-neutral reason, but also the state's not required to utilize all of its peremptory strikes. That's not a requirement. And it also does not have a duty to ensure that a minority juror makes it onto the panel. So again, those are also considerations. At this point, the state believes that paleo is it's controlling, it's dispositive. We believe that it is controlling in this case. And again,
If I could just ask on the pattern, if the state had used peremptories on 2 African American jurors, would that have triggered the need for something? Is that a pattern then? Is 2 is a pattern, but 1 is not?
it could be, yes. But again, those are not the facts that we have here, but they could be a pattern. Paleo is a little instructive in this point, in this regard. There we had the affirmative striking of a Hispanic juror, and the state waived 2 of its peremptory strikes, and ultimately the court noted it waived the only sole remaining Hispanic juror on the panel. In that case, we have a disproportionate impact, and still the court's impliedly, if we can read in its argument, that 2 acts, even if improper or eliminated all Hispanic jurors, wouldn't be sufficient to overcome the defendant's burden for a Batson violation. And along those lines, KAVU the burden for proving whether a Batson violation had occurred always falls on the defense, and in this case it was on KAVU. And below, again, he did not allege there was a disparate impact. He didn't allege there was a pattern of striking. He only relied on the fact that there was a waiver that coincidentally eliminated a juror who was African American, and we know from Paleo that a waiver on its own does not establish a prima facie case, and for that reason, the court's denial of relief was consistent and it was proper and certainly does not constitute clear error.
Well, how many strikes does one party have?
6 for non-capital cases.
Okay, so we have this word pattern. 1's not a pattern.
No.
2, is there any common law interpretation further explaining that? We have to consider the universe, which is only 7 opportunities. What is a pattern within the universe of 7?
The state would not like to speculate on that, but at least 3, if we look at Paleo as an example, you would need at least 3 acts total, whether they're affirmative strikes or waivers combined.
And pattern's not talking about a particular prosecutor?
No. It just is a pattern of strikes that eliminates a cognizable group of people.
In that case?
In that case, yes. And here again, though, as the court earlier pointed out, there was a race-neutral reason for striking juror 18. So if we were going to look at whether or not a pattern existed here, we cannot consider juror 18. And even if we did, an improper act of 1 would not constitute a pattern. In addition, to go back to your earlier question, Judge Weinweg, a pattern, by common understanding, would be a series of improper acts, would suggest at least at a minimum 2, or if again we look at Paleo, it would be at least 3, and we don't have that here. If the court has no further questions, state rests on its brief. Thank you.
All right. Well, thank you very much, counsel, for your arguments. We will take it under advisement, and we are adjourned.